I understand that, Mr. Cox, I don't mean to be rude, the importance of precedent and all that, but didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
John Kennedy absolutely refused to let this hearing turn into a legal word game. While the lawyers tried to bury the issue under layers of explanations, Kennedy kept dragging the conversation back to one simple question: should race ever decide how Americans are treated by the government? That's the moment this hearing exploded. Kennedy wasn't interested in academic theories or complicated courtroom language. He wanted a direct answer the average American could understand. And the tension in that room shot through the roof when the witnesses struggled to give one. What really stood out was Kennedy's argument that the Supreme Court is sending a clear message across multiple rulings: race should be off the table in public decision-making. Supporters see that as restoring equal treatment under the Constitution, while critics argue certain race-based remedies are still necessary. Either way, this exchange exposed a much bigger battle brewing in America, and judging by the intensity of this hearing, it's only getting started. If you want more political moments like this, hit subscribe and stay tuned because these clashes are becoming impossible to ignore.
Kennedy.
Thank you, Mr. Chairman. Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going
lecture.
to tell you what SFFA, how SFFA applies to Calais.
Did he get it right, or
he did not get it
wrong?
right? Okay. So in under application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
All right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's
want to have a fight.
Justified the creation of the plan.
I don't want to have a fight. Can you just tell me, and you're smart, and I I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was
No,
ignoring.
you're speaking like a lawyer, okay? And I'm tired of, I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Graham got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, no, I'm totally respectful. Yeah, obviously, I think he's got a good handle on it.
I understand that, Mr. Cox, I don't mean to be rude, the importance of precedent and all that, but didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't
That
want to
was-
answer
that's
my
what was
question, do
challenged.
you, Mr. Cox?
I'm answering your question. It
No,
may
you're
not-
not.
It may be an answer that you
No,
don't
you're
like or my
not.
colleagues don't
No,
like.
you're not.
But I'm answering
You're
your
not.
question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So the court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there was intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be
Sure you
used
do.
to help
Do you
a
think
person?
race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that
No,
question
I didn't
means.
think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you know, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed, I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe.
And
now, if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear
and
you.
saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, You need to craft a remedy that addresses that.
Sure.
Senator
And-
Whitehouse. Senator Whitehouse.
I'm sorry.